Hello everyone and welcome to the Fair Work Ombudsman's webinar, The National Employment Standards, Essential Knowledge for Small Businesses. My name is Nick and I'll be taking you through our presentation today. And before we begin, I'd like to acknowledge the traditional custodians of country throughout Australia and their connections to land, waters, skies and community. I also wish to pay my respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples here today. And I'm coming to you from central Victoria on the lands of the Dja Dja Wurrung. Now, today's session is about giving you the essential information small businesses need to know about the National Employment Standards, or the NES as we know it. More specifically, we'll take you through what the NES are and who they cover, an overview of the NES minimum entitlements, including which entitlements apply to full-time, part-time and casual employees, and where to find further information and resources for small businesses. Now, a few things before we begin. Firstly, we won't be answering any live questions today, but we do have a couple of helpers in our Q&A section of the webinar. So if you do have any questions, they'll be able to point you in the right direction where applicable. So please feel free to pop questions into the Q&A portal. It should look like an envelope with a question mark. Also, don't worry about taking notes on website addresses or any tools or resources mentioned in the webinar. So for those of you that have registered, you'll receive an email after the session with a host of links to the information we cover today. And if you're watching on catch up on YouTube, you'll be able to access the links in the video description. The Fair Work Ombudsman, or the FO as we're often referred to, has taken care to ensure that the information in this presentation is current at the time of this webinar. The information in this presentation is general in nature, so how it applies will depend on your personal situation. For more information, please visit our website at fairwork.gov.au or call us on 131394. Okay, let's get started. The NES make up the minimum entitlements that must be provided to all employees covered by the National Workplace Relations System. These are the basic entitlements that employees get. All other workplace instruments, such as an award, employment contract, and registered agreements, cannot provide for conditions that are less than the NES. These instruments also cannot exclude any of the NES entitlements. Now, we'll cover the NES entitlements in a moment, but whether they apply to your employees will depend on their employment type, this being either full-time, part-time or casual, and in some circumstances, their length of employment. So as you can see on the slide, these are the NES minimum entitlements for employees. Let's now look at these entitlements in more detail. The first NES entitlement that I'm going to cover is maximum weekly hours. Now, one of the questions we often get is, what would be considered as regular hours for a working week? The NES establishes the maximum weekly hours for employees, the circumstances in which an employee may refuse a request or requirement to work additional hours if the hours are unreasonable, as well as arrangements for the averaging of hours of work. An employer must not request or require an employee to work more than the following hours of work in a week, unless the additional hours are reasonable, and they are, for a full-time employee, 38 hours, that is, unless their award or enterprise agreement specifies different hours, or for an employee who isn't full-time, the lesser of 38 hours, or the employee's agreed ordinary hours of work in a week. When working out the hours an employee has worked in a week, this must be taken to include any hours of leave or absence, whether paid or unpaid under the NES, that is authorised by the employer or provided for under the employee's terms of employment, or permitted under Commonwealth, state or territory laws, or an instrument in force under such law. Importantly, employees can refuse to work additional hours if those hours are unreasonable. So in determining whether additional hours are reasonable or unreasonable, certain factors must be taken into account. For example, any risk to employee health and safety, the employee's personal circumstances, including family responsibilities, the needs of the workplace or enterprise, any notice requirements, and the nature of the employee's role and their level of responsibility. There are other factors that may also apply. For the full list, we'll include a link in our follow-up email. It's also worth noting that an award or registered agreement may allow for hours to be averaged over a period of time that is greater than a week. And if you'd like to learn more about averaging arrangements and an example of how this might apply, you can find this information on the fact sheet we will share with you. That's an overview of the maximum weekly hours. Let's now move on to the next NES entitlement, requests for flexible working arrangements. Now, some employers have the right to request flexible working arrangements. Flexible working arrangements can take a number of different forms, including changes to hours of work, such as changes to start and finish times, patterns of work, for example, split shifts or job sharing, and where the work is performed, such as working from home. Full-time and part-time employees can request flexible work arrangements if they've worked for the same employer for at least 12 months and they are the parent or have responsibility for the care of a child who is school-aged or younger. They are a carer under the Carer Recognition Act of 2010. They're a person with a disability. They are 55 years of age or older. They are pregnant. They are experiencing family and domestic violence, or provide care or support to an immediate family or household member who is experiencing family and domestic violence. For casual employees, they can request flexible work arrangements if they meet one of the criteria that I just outlined. They've been working for the same employer on a regular and systematic basis for at least 12 months, and there's a reasonable expectation that this regular and systematic work will continue. Both employees and employers need to follow certain rules when requesting and responding to flexible working arrangements. To help with this, our website has a dedicated best practice guide on flexible working arrangements with guidance for managers and employers on how to respond to a request, including when a request may be approved or refused and what may be considered reasonable business grounds for refusing a request. Employers can also find our Workplace Flexibility online course in our online learning centre on the website. And there will be links to this guide and our online learning centre in that follow-up email. Now, if a dispute about these requests can't be resolved at the workplace, the Fair Work Commission can help. Next, we'll have a look at the pathways available for casual employees who want to move to permanent employment, either as a full-time or part-time employee. Now, employees who start as a casual will stay casual until their employment status changes, either through accepting an alternative employment offer and starting work on that basis, or changing to permanent under the rules in the NES, their award or agreement, or a Fair Work Commission order. Firstly, it's important to note that an employer and their casual employee can agree to a change to permanent employment at any time. In addition, the NES now provides a formal pathway called the Employee Choice Pathway, which gives eligible casual employees the right to notify their employer of their intention to change to permanent employment. An employer can only refuse the notice for certain reasons. To access this pathway, a casual employee must have been employed for at least 6 months or 12 months if they work for a small business employer, and they must also believe that they no longer meet the legal definition of a casual employee. There are also certain situations where an employee cannot provide a notice. For example, if there is already an ongoing dispute about changing to permanent employment, or if a previous notice was refused or resolved within the last 6 months. When an employee submits a notice, the employer must first consult with them. Now, this discussion should cover important issues such as whether the employee will become full-time or part-time, what their hours of work will be, and when the change would take effect. The employer must then respond in writing within 21 days, either accepting or not accepting the change. If the request is accepted, the response must confirm the employer's new status, hours of work, and the commencement date of the change. And in most cases, the change takes effect from the first day of the employer's next full pay period, unless another date is agreed. If the employer does not accept the request, they must provide written reasons. Refusal is only permitted in specific circumstances, such as where the employee still meets the definition of a casual employee, there are fair and reasonable operational grounds, or accepting the change would breach legal recruitment requirements. Employers can use our responding to an employee's notice to change to permanent employment checklist and response template to confirm your next steps when either accepting or not accepting the change. And again, a link will be included in the follow-up email. Finally, employees are protected when exercising these rights. Employers can't take certain actions to avoid their obligations or an employee's right to change to permanent employment. Now, this includes reducing or varying the employee's hours, altering work patterns, terminating employment, or taking adverse action to avoid their obligations. And again, if the problem is unresolved, employers and employees can seek further help from the Fair Work Commission. The next NES entitlement I'd like to cover is parental leave and related entitlements. Eligible employees in Australia can take unpaid parental leave when they give birth, their spouse or de facto partner gives birth, or they adopt a child under 16 years of age. Eligible employees can take up to 12 months of unpaid parental leave and can request to extend their leave for an additional 12 months. Now, to be eligible for parental leave, employees must have or will have responsibility for the child's care and must have worked for their employer for at least 12 months before the leave starts or the expected birth of the child, if the leave is commencing before the child is born. Casual employees are entitled to take unpaid parental leave if they work for their employer on a regular and systematic basis for at least 12 months and have a reasonable expectation that this will continue if not for the birth or adoption of the child. Unpaid parental leave must be taken within 24 months of the child's birth or placement. Unpaid parental leave can be taken as a single continuous period, flexibly, or a combination of both. Pregnant employees can start their leave from 6 weeks before the expected date of birth up until 24 months after their child has been born. They may start their leave earlier than the 6 weeks before the expected date of birth if agreed to with their employer. And in some situations, an employer may direct a pregnant employee to commence their parental leave in the 6 weeks before the expected date of birth. Employees can take part of their 12-month parental leave flexibly. This means that they can take one or more individual days or separate periods of one or more days off work using part of their 12-month parental leave entitlement. Now, there are rules regarding the number of days of available flexible parental leave an employee can take, depending on when the child was born or placed for adoption. Flexible parental leave must be used within the 24-month period starting from the date of birth or placement of the child. The combined totals of flexible and continuous parental leave cannot exceed 12 months unless the employee has been granted an extension. To apply for the leave, employees need to provide their employer with written notice of their intention to take leave and confirm their leave dates. The notice should include the expected start and end dates, and in most cases, employees need to provide this notice within at least 10 weeks before the leave is due to start and confirm the dates in writing at least 4 weeks before the leave begins. If an employee is unable to provide the required notice, for example, because a baby is born prematurely, they are still entitled to take the leave, but must notify their employer as soon as reasonably possible. And we have a dedicated web page on parental leave and related entitlements, covering what employers need to know before, during, and after parental leave. The page includes all the information I've just discussed, along with additional guidance on a range of topics such as returning to work and flexible working arrangements, just to name a few. And the page also includes a video on unpaid parental leave. And we've added the link to the dedicated page in the email that will be sent to you later. The next NES entitlement is annual leave, or what many people know as holiday pay. As many of you would already be aware, all employees, other than casual employees, are entitled to paid annual leave. Eligible employees receive 4 weeks of annual leave each year based on their ordinary hours of work. And for part-time employees, annual leave accrues on a proportional basis. For example, an employee who works 20 hours per week will accrue 80 hours of annual leave over a year, which is equivalent to 4 weeks of their ordinary working hours. Now, while awards and enterprise agreements can't provide less than the NES entitlement, they may offer more generous annual leave arrangements. Some shift workers may be entitled to an additional week of annual leave where their award or enterprise agreement contains specific shift work provisions and defines them as shift workers for the purposes of the NES. Annual leave starts accruing from an employee's first day of employment, even if your employee is serving a probationary period. It accrues progressively throughout the year, and any unused annual leave balance carries over from year to year. Employees continue to accrue annual leave while on other forms of leave, including paid annual leave, paid sick and carers leave, paid family and domestic violence leave, community service leave, including jury duty, and long service leave. However, annual leave does not accrue when the employee is on unpaid annual leave, unpaid personal carers leave, unpaid parental leave, or when annual leave is being cashed out. Employees also don't accrue annual leave while they're receiving payments under the paid parental leave scheme if they're taking unpaid leave from their employer during that period. It's also important to remember that when employment ends, an employer must pay an employee any untaken annual leave. That payment must be the same amount the employee would have received had they taken the leave. And this includes annual leave loading if the employee would ordinarily receive it when taking annual leave. Employers and employees can use our pay and conditions tool to calculate an annual leave balance. And we also have a fact sheet called the Annual Leave and National Employment Standards, which we will provide you with information such as when annual leave can be taken, payment when annual leave is taken, annual leave in advance, and more. Now, there are several other leave entitlements also covered by the NES, including personal/carers leave, compassionate leave, and family and domestic violence leave. Now, let's have a look at each of these. Now, I'm sure you've all heard of personal leave or sick leave and carers leave. These entitlements allow employees to take time off to deal with their own illness or injury, caring responsibilities, or family emergencies. Full-time and part-time employees can take paid sick leave if they're unable to work because of a personal illness or injury. Full-time employees are entitled to 10 sick or carers days per year. For part-time employees, this entitlement is provided on a pro-rata basis. Unused sick and carers leave carries over from year to year. However, unlike annual leave, it isn't paid out when employment ends. Employees can also take paid or unpaid carers leave when they need to care for or support a member of their immediate family or household because of personal illness, injury, or an unexpected emergency. Paid carers leave is available to full-time and part-time employees, while casual employees don't accrue paid sick leave and carers leave under the NES. But they are entitled to 2 days of unpaid carers leave for each occasion where they need to provide care or support. Full-time and part-time employees can also take unpaid carers leave if they've exhausted their paid sick and carers leave entitlement. Sick leave and carers leave form part of the same entitlement of the 10 days per year, which is commonly referred to as personal/carers leave. One of the more common questions we receive is, who is considered an immediate family member or household member for this carers leave? So an immediate family member includes an employee's spouse or former spouse, de facto partner or former de facto partner, a child, parent, grandparent, grandchild, sibling, or child, parent, grandparent, grandchild, or sibling of the employee's spouse or de facto partner, or former spouse or de facto partner. This definition includes step relations, for example, step parents and step children, as well as adoptive relations. A household member is anyone who lives with the employee. Now, employees need to let their employer know if they're taking sick or carers leave, and employers may also request evidence to support the leave being taken. For more information, you can refer to our Notice and Medical Certificates page. All employees, including casual employees, are entitled to compassionate leave, which is also referred to as bereavement leave. Now, employees can take compassionate leave if a member of their immediate family or household dies or contacts or develops a life-threatening illness or injury. a baby in their immediate family or household is stillborn, they experience a miscarriage, or their current spouse or de facto partner experiences a miscarriage. Employees are entitled to 2 days compassionate leave each time they meet the criteria. Full-time and part-time employees receive paid compassionate leave, while casual employees are entitled to unpaid compassionate leave. Employees can take compassionate leave as a single continuous 2-day period, 2 separate periods of 1 day, and any 2 separate periods as agreed with their employer. Compassionate leave doesn't accrue over time, isn't part of an employee's personal/carer's leave entitlement, and it isn't paid out on termination. Employers can take compassionate leave whenever it's needed, but they must let their employer know as soon as possible that they are taking the leave. And finally, all employees, including casuals, are entitled to 10 days of paid family and domestic violence leave each year. An employer that is experiencing family and domestic violence can take this type of leave if they need to do something to deal with the impact of family and domestic violence, and it's not practical for them to do so outside of their work hours. For example, this could include making arrangements for their safety or safety of a close relative, and that includes relocation, attending court hearings, or accessing police services. An employee's full 10-day entitlement is available immediately at the start of each year of employment, and it resets on their work anniversary. It doesn't accumulate from year to year, and it isn't paid out when employment ends. Paid family and domestic violence leave is a standalone entitlement. This means it's separate from other forms of leave, such as annual leave or paid personal and carers leave. And I've attached the link in our follow-up email to a guide that we've developed, our really useful employer guide to family and domestic violence. And I always encourage employers to proactively have a look at this one. If one of your employees does come to you and disclose that they're experiencing family and domestic violence, it's important that you understand how to respond in a way that best supports your staff member. Another NES entitlement is community service leave. This entitlement allows employees, including casual employees, to take time off work for activities such as voluntary emergency management activities or jury service. Now, when we talk about voluntary emergency management activities, we're referring to activities undertaken in response to an emergency or natural disaster, and these include things such as bushfires, floods, storms, cyclones, search and rescue operations, emergency evacuations, or supporting communities affected by other natural disasters. To access community service leave for emergency management activities, an employee must be responding to an emergency or natural disaster, they must be participating on a voluntary basis, and they must be a member of a recognised emergency management body, such as the Country Fire Authority or the State Emergency Service. Community service leave for emergency management activities is unpaid. However, different arrangements apply for jury service, with payment entitlements available for eligible full-time and part-time employees. There is no limit on the amount of community service leave an employee can take. Employees are entitled to be absent from work for the time they are engaged in the activity, as well as any reasonable travel time and rest time required immediately afterwards. Employees should notify their employer of their absence as soon as practicable and provide an indication of how long they expect to be away. And employers may also request an employee who has given notice to provide evidence that they're actually entitled to community service leave. And you'll find more information about the rules and eligibility requirements relating to community service leave on our website at fairwork.gov.au/community service leave. The next NES entitlement I will talk about is long service leave. Most employees' entitlement to long service leave comes from long service leave laws in each state or territory. Now, these laws set out how long an employee has to be working to get long service leave, for example, after 7 years, and how much long service leave the employer actually gets. In some states and territories, long-serving casuals are eligible for long service leave. All Australian states and territories have legislation to provide employees in some industries with access to portable long service leave. And these include the security, community services, building and construction, coal mining, and contract cleaning industries. Now, this means an employee keeps their long service leave entitlement even if they work on different projects for one or more employers. And to read more about long service leave, or if portable long service leave applies to your employees, read our long service leave fact sheet, and we'll again provide a link in the follow-up email. All employees have the right to be absent from work on a public holiday and should have the choice of whether to work on that public holiday or not. Employers can ask employees to work on a public holiday, however, the request must be reasonable. Employees are protected from adverse action if they reasonably refuse to work on a public holiday. Now, there are different entitlements depending on whether an employee works on the public holiday or not. So if an employee works on a public holiday, an award or registered agreement may provide entitlements such as extra pay, for example, public holiday rates, may provide for taking an extra day off, or minimum shift lengths. If an employee does not work on a public holiday, they could be entitled to payment for the day. Employees who would ordinarily have worked on the day the public holiday falls are generally entitled to be paid their base rate of pay for the ordinary hours they would have worked if they had not been away because of the public holiday. And under the NES, this does not apply to casual employees. If an employee is taking paid leave, such as annual leave or paid sick leave, they are still entitled to be paid for the public holiday. The public holiday is not counted as annual leave or sick leave, so in other words, the public holiday hours are not deducted from the employee's accrued leave balance. Our public holidays webpage provides further information about what employers should consider when rostering employees to work on a public holiday. And this includes guidance on public holiday entitlements, working on a public holiday, not working on a public holiday, substituting public holidays, and situations where employees work outside their usual state or region on a public holiday. From 1 January 2024, superannuation was added as a NES entitlement. Under the superannuation guarantee, employers must pay superannuation contributions of 12% of an employee's qualifying earnings when an employee is aged 18 years or over, or under 18 years of age and working more than 30 hours a week. If eligible, the super guarantee applies to all types of employees, including full-time, part-time and casual employees. Independent contractors who are paid mainly for their labour, along with temporary residents, are also eligible for superannuation. From 1 July 2026, employers must pay their employees superannuation contributions each payday. If super contributions aren't paid on time, employers may be liable for the superannuation guarantee charge. And for more information, you can visit our page, Payday Super, new rules starting 1 July 2026. The flow can provide information about superannuation as a NES entitlement and any additional superannuation terms that may apply under awards. However, the Australian Taxation Office, or ATO, is responsible for providing advice and assistance on superannuation matters, including the superannuation guarantee. To read more about this, you can visit our tax and superannuation page on our website. The next NES entitlement I'll cover is notice of termination and redundancy pay. The notice period is the amount of notice that an employer or employee needs to provide before employment comes to an end. Under the NES, when ending the employment of a full-time or part-time employee, an employer must provide written notice of the employee's last day of employment. This requirement does not apply to casual employees. The minimum notice period an employer must provide under the NES is based on the employee's period of continuous service. For example, if a permanent employee has worked for their employer for at least 1 year, but less than 3 years, the employer must provide a minimum of 2 weeks' notice. Employees are entitled to an additional week of notice if they are over 45 years of age and have completed at least 2 years of continuous service with the employer. An employer may require an employee to work through their notice period, make a payment instead of notice, which is often referred to as pay in lieu of notice, or use a combination of both. Where notice is paid out, the amount paid must be equal to the full amount the employer would have received if they had continued working until the end of the notice period. It's also worth noting that there are specific rules about what must be included in an employee's final pay. If an employee chooses to end their employment, the amount of notice they need to give to their employer may be set out in an award, enterprise agreement, or employment contract. The NES also provides employees with an entitlement to redundancy pay in certain situations. Now, redundancy occurs when an employer either doesn't need an employee's job to be done by anyone or becomes insolvent or bankrupt. Redundancy can arise for a range of reasons, including when a business introduces new technology. For example, the job can be performed by a machine, when the business experiences a slowdown due to lower sales or production, the business closes down, relocates interstate or overseas, or restructures or reorganises because a merger or takeover happens. When an employer makes an employee's job redundant, they may need to pay the employee severance or redundancy pay. And our notice and redundancy calculator can help employers to calculate notice and redundancy entitlements. This brings us to the final NES entitlement, and this relates to the Fair Work Information Statement and the Casual Employment Information Statement. Employers are required to provide every new employee with a copy of the Fair Work Information Statement before they start work or as soon as practicable after they commence employment. The Fair Work Information Statement contains information on a range of important workplace topics, including the NES, the right to request flexible working arrangements, the national minimum wage, modern awards, individual flexibility arrangements, termination of employment, and the role of the FWO and the Fair Work Commission. Employers must also provide casual employees with a casual employment information statement before they start work or as soon as practicable after they commence employment. Employers are also required to provide the casual employment information statement at certain points throughout the casual employee's employment. This is for small business employers after 12 months of employment, and for other employers after 6 and 12 months of employment, and then after every 12 months after that. The casual employment information statement includes information about the definition of a casual employee, how casual employment can be changed, reasons where an employer may not accept an employee's notification, and the role of the Fair Work Commission to deal with disputes. And whilst we're on the subject of information statements, there is also a separate information statement that you need to provide if you're hiring someone on a fixed term basis. The fixed term contract information statement provides information about fixed term employment, including rules about when fixed term contracts can be made. Now, employers can provide the Fair Work Information Statement and, where applicable, the Casual Employment Information Statement and the Fixed Term Contract Information Statement in several ways, including in person, by post, by email, or electronically through an intranet system. And we've included a link to the Fair Work Information Statements in that follow-up email also. So that brings us to the end of our overview of the National Employment Standards. But before we finish up, I'd like to mention where you can get our free information, tools and resources to help small businesses understand their rights and obligations. So this is our webpage here at fairwork.gov.au. And on our website, you'll find guides, fact sheets, templates, calculators, and other useful resources. Now, if you want to read more about the NES, it's as easy as scrolling up the left-hand corner of their website and clicking on the menu, dropping down to employment conditions, and then going across to the National Employment Standards section. And here you'll find all that information that I've talked about through today. I also want to show you our major resource for small businesses, our Small Business Showcase. As with searching for the NES, getting there is just going and clicking on the menu again, then down to the Find Help For section, and across to Small Business. And this is our Small Business Showcase. The Small Business Showcase is a virtual one-stop shop that consolidates the FWO's key online resources in a single, easy-to-access and navigate hub, making it easier for small businesses to access information about workplace obligations. From the homepage, employers can navigate to the 12 topic pages containing links to key resources and tools available from the flow on a selected topic. The topics are based around the life cycle of a typical employment relationship, and these include some of the topics that we've just gone through today, such as leave, flexible work and permanent employment requests, and ending employment. And down in the middle of the bottom section there, you'll see the topic button for accessing our employer advisory service. This service provides small business employers with free tailored written advice about pay and conditions to help ensure small businesses are meeting their obligations under the Fair Work Act. All of our resources for small businesses and managers can be found here, all in the one place. And as we always mention, of course, they are free. Now, if you'd like to get in touch with us regarding workplace entitlements, you can do so by visiting the FRO's website and subscribing to our email updates, contacting us on 131394, or through our translating and interpreting service on 131450, or following us on our social media channels. Finally, we regularly deliver webinars tailored for different industries and audience, including small business. Please check our dedicated webinar page at fairwork.gov.au/webinars for information about any of our upcoming webinars. Now, that's all we'll have time for today. Thank you to everyone who joined us. We're going to end the webinar now, but there will be a quick survey after the webinar, and we'd really appreciate if you could answer a few questions to help us develop and improve our webinar program. It should only take a minute or so to complete, and we would really value your feedback. So thank you for your time and enjoy the rest of your day. Goodbye.